Hi, this is Sarah Cates, a partner with the law firm of Block & Chapleau.
And I'm Mark Chapleau.
Here at Block & Chapleau, the 6 most commonly asked family law questions we receive are 1. Could I be common law married? 2. What is my exposure to maintenance or alimony? 3. How do I force my ex to abide by the court's orders? 4. How is the court going to divide our property? 5. What happens if a restraining order is filed? And 6. Is a paternity test needed? First, could you be common law married? The short answer to this is yes, since Colorado is one of the few states that still recognizes common law marriage. However, just living together or cohabitating, even for many years, does not make you common law married. Although living together is a factor, the main consideration is whether you consider yourselves married and whether you've held yourselves out to the community as a married couple. This can be shown in several different ways. The most common being the filing of joint tax returns, joint ownership of property, maintaining joint health insurance, publicly referring to each other as spouses. If it's determined that you are in fact common law married, you must get a legal divorce because there's no such thing as a common law divorce. It's important to note that common law marriage may also be applicable to same-sex couples.
Second, what is your exposure to maintenance? Maintenance is what the courts used to call alimony, and your exposure depends on several factors, including disparity in incomes, the length and standard of living during the marriage, and whether your spouse can meet their financial needs without your help, just to name a few. A statute that was passed in 2014 now provides an advisory guideline formula for the amount and length of maintenance, but this formula only serves as a guideline. As a result, maintenance remains one of the grayest areas of family law because the court still has wide discretion in deviating from this guideline.
Third, how do you enforce the court's orders if your ex will not comply? Seeking contempt is your best bet in such circumstances. Contempt can be remedied in many ways, ranging from simple compliance to fines and even jail time. If you are facing a contempt, it's highly advised that you seek the assistance of an attorney, as it could lead to severe consequences.
Fourth, how is property divided in Colorado? A common misconception is that Colorado is a 50-50 state. However, Colorado is an equitable division state, meaning property, such as your house, retirement accounts, personal property, and the like, can be divided disproportionately if the court finds it to be fair under the circumstances.
Fifth, what happens if a restraining order is filed? Although restraining orders are actually needed in some cases, people often use them for improper reasons, like to force the other person out of the house or even to get a leg up in the divorce case. The biggest mistake you can make when facing a restraining order is not to hire an attorney and allow it to be made permanent, because what many people do not realize is that once permanent, the restraining order cannot be modified for 2 years and will show up on every background check that's run, which may affect your job. It's also important that if you are served with a restraining order, that neither you nor anyone on your behalf contact the other party, as this could be a violation. A violation of a protection order is a criminal offense for which jail can be imposed.
Finally, is a paternity test needed? The answer to this question is almost always yes. If you waive your right to a test and admit paternity, your right to later request a test is forever waived, even if you later learn that the child is not biologically yours. If any of these questions have crossed your mind, or if you're simply interested in finding out more about your rights in a divorce or other family law matter, contact Block & Chapleau and schedule a consultation.